Yes, hello. Can you hear us?
Hello?
Mr. Greer?
Oh, yes, this is me.
Yes, your matter has not begun yet. We are just starting the meeting.
Okay, thank you.
We have recording, Chair Wolf.
Okay, thank you. Okay, let's call this meeting to order, 4:08. Please call the roll.
Second. Chair Wolf.
Present.
Chair Wolf present. Member Forsley? Member Forsley not present. Member Neighbors?
Present.
Member Neighbors present. Member Highland? Member Highland? Member Highland not present. Vice Chair Yankee?
Present.
Vice Chair Yankee present. Member Stein?
Present.
Member Stein present. Member Wong?
She'll be late.
She'll be late, exactly. Member
Not
Padmanabhan? I'm sorry?
Not present.
Yeah. Member Padmanabhan?
Present.
Member Padmanabhan present. Member LaHood?
Present.
Member LaHood present. Member Schmidt?
Present.
Member Schmidt present. 2, 3, 4, 5, 6, 7. We have 7 members. We have a quorum.
Member Highland present.
Oh, Member Highland present. Terrific. Thank you so much.
Okay, great. Let's start with the preamble.
Did you want to introduce the meeting, Chair Wolf, or would you like me to?
I did. Said to call
Okay.
the meeting to order at 4:08 p.m.
Okay. Shall I read public comment number, remote access?
Please
The public
proceed.
comment. The public comment call-in phone number is 415-906-4659. Meeting ID is 590-728-229 #. If you wish to make a statement during general public comment, please press *6 and unmute your telephone to speak. Please press *6 to mute your telephone once you are done with your statement. Remote access to information and participation. In accordance with Governor Newsom's Executive Order N-33-20, declaring a state of emergency regarding the COVID-19 outbreak, and Mayor London N. Breed's proclamation declaring a local emergency issued on February 25, 2020, including the guidance for gatherings issued by the San Francisco Department of Public Health Officer, aggressive directives were issued to reduce the spread of COVID-19. On March 17, 2020, the Board of Supervisors authorized their board and committee meetings to convene remotely via Microsoft Teams and will allow remote public comment via teleconference. Members of the public may participate by phone or may submit their comments by email to cheryl.leger@sfgov.org. That's CHERYL.LEGER@sfgov.org. All comments received will be made a part of the official record. The Sunshine Ordinance Task Force agendas and their associated documents are available at sfbos.org/sunshine. As the COVID-19 disease progresses, please visit the Sunshine Ordinance Task Force website regularly to be updated on the current situation as it affects the legislative process.
Meeting decorum. Any member of the Sunshine Ordinance Task Force may call for decorum due to disorderly conduct of meeting participants. Persons who engage in threatening and/or menacing behavior may be asked to leave. Please call the first item.
Call to order, roll call, and agenda changes. I know of one agenda change, item number 6, file number 20056. The petitioner sent me a letter via facsimile. I received it Friday morning, stating that they had issues beyond their control and had to request, on late notice, request a postponement of their case.
Okay, I also received a direct contact from the complainant, and they absolutely had prepared to be here, but it was a situation like our administration said, it was completely out of their control. Let's see. Well, hold off on that for as far as taking action. There's another item, item number 12. There's no attachment, so we have no way of knowing what we're supposed to be taking action on here. So unfortunately, we're not going to be able to hear this item today. We did have communication and notification from the complainant for those items. They're aware of it, and we'll be continuing this item, and most likely call a special meeting just for this item. So item number 12 is pulled from the agenda. Any other changes or adjustments to the agenda? Okay, so before we do that, we have to exercise item 1A. And is there a presentation by somebody? Is legal counsel present? Who's legal counsel today?
Hi, this is Helen Castillo.
Hi, Helen. Are you familiar with 1A, with that Governor Newsom?
Helen Castillo.
I'm sorry?
Can you hear me?
Yes.
Okay.
Are you familiar with it?
With 1A, yes.
Okay. Can you, are you prepared, or can you give a short explanation of what this is all about?
Sure. Basically, Assembly Bill 361 requires that that after September 31st, every 30 days, a body like the Sunshine Ordinance Task Force must make findings to be able to continue meeting remotely by going through, sorry, I'm looking for the documents. By finding that you've considered or reconsidered the circumstances of the state of emergency, and that either you've decided that the state of emergency continues to directly impact the ability of the policy body members to meet safely, and that the state or local officials continue to impose or recommend measures to promote social distancing. So under AB 361, you have to move and decide as a committee whether to adopt the findings that you will be presenting. And I should warn that should you decide as a body that you are not going to, you decline to approve the findings that the chair will present, then the remote meeting can no longer continue, so you have to adjourn. So I just want to say that at the outset so that it's clear that should you decide not to approve, then we have to disband.
Okay, great. So members, as you can see in the attachment, there's a resolution that has 2 pages of whereases explaining what this is about in more detail. I think it'll be a little more expedient if I just read the last whereas and the resolves, and then we can have some discussion, some public comment, and take action. Whereas the Sunshine Task Force has met remotely during the COVID-19 pandemic and can continue to do so in a manner that allows public participation and transparency while minimizing health risks to members, staff, and the public that would be present with in-person meetings while this emergency continues. Now, therefore, be it resolved, the Sunshine Ordinance Task Force finds as follows. As described above, the state of California and the city remain in a state of emergency due to the COVID-19 pandemic. At this meeting, the Sunshine Ordinance Task Force has considered the circumstances of the state of emergency. 2, as described above, state and city officials continue to recommend measures to promote physical distancing and other social distancing measures in some settings. 3, as described above, because of the COVID-19 pandemic, conducting meetings of this body, the Sunshine Ordinance Task Force, and the Education Outreach and Training Committee, Complaint Committee, Compliance and Amendments Committee, Rules Committee, Information Technology Committee, Ad Hoc Committee in person would present imminent risks to safety of attendees, and the state of emergency continues to directly impact the ability of members to meet safely in person, and be it further resolved that for the next 30 days, meetings of the Sunshine Ordinance Task Force and the Education Outreach and Training Committee, Complaint Committee, Compliance and Amendments Committee, Rules Committee, Information Technology Committee, Ad Hoc Committee will continue to occur exclusively by teleconferencing technology and not by any in-person meetings or any other meetings with public access to the places where any policy body member is present for the meeting. Such meetings of the Sunshine Ordinance Task Force and Education Outreach and Training Committee, Complaint Committee, Compliance and Amendments Committee, Rules Committee, Information Technology Committee, Ad Hoc Committee that occur by teleconferencing technology will provide an opportunity for members of the public to address this body and all the committees, and will otherwise occur in a manner that protects the statutory and constitutional rights of parties and the members of the public attending the meeting via teleconferencing, and be it further resolved that, or finally resolved that that Cheryl Leger of the Sunshine Ordinance Task Force is directed to place a resolution substantially similar to this resolution on the agenda of a future meeting of the Sunshine Ordinance Task Force within the next 30 days. The Sunshine Ordinance Task Force does not meet within the next 30 days. Cheryl Leger is directed to place such a resolution on the agenda of the next meeting of the Sunshine Ordinance Task Force, and that ends the resolution. So I'll open it up to Sunshine Task Force members for any discussion.
Do we need a discussion, or are you just looking for a motion?
Well, we must always ask for discussion if there's an action item. So if there's no discussion, then I'll open it up to public comment, and then we'll take a vote. Okay, no, I don't see any hands raised or anybody
Do we need a second on that?
flagging me. So let's open it up for public comment, and I'll hand the controls over to
So are you
Mr.
taking what I said is I motion that we approve this resolution?
We have to wait till public comment before
Okay.
or you can make a motion, sure, and then we can take public comment. Are you making a motion?
Whichever you prefer in terms of
fine.
efficiency.
Make the motion. That's fine.
I make a motion that we approve this resolution.
Okay, is there a second?
Vice Chair Yankee will second.
And sorry, that was Member LaHood making an original motion.
Right. So motion made by Member LaHood, second by Vice Chair Yankee. Okay, public comment.
Please put David Pilpel in the queue. Thanks.
Do we have other public commenters? Chair Wolf, looks like we only have one public commenter, Mr. Pillow.
Proceed.
Thank you, David Pilpel. So I've reviewed this issue, commented on it several times in the last couple of days. I would suggest the following edits on the portion that Chair Wolf just read. I would word it as follows: whereas the Sunshine Ordinance Task Force, etc. on that whereas. On the next resolved, one at this meeting, the Sunshine Ordinance Task, yeah, that's fine. On sub 3 on the next page, as described above, because of the COVID-19 pandemic, conducting meetings of this body and its committees in person, blah, blah, blah. And be it further resolved that for at least the next 30 days, meetings of the Sunshine Ordinance Task Force and its committees will continue to explore, next sentence, such meetings of this body or such meetings of the Sunshine Ordinance Task Force and its committees that occur by blah, 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 will provide an opportunity for members of the public to address this body and its committees and will otherwise occur, etc. And be it further resolved that the clerk or administrator of the Sunshine Ordinance Task Force is directed, Last sentence, if the Sunshine Ordinance Task Force does not meet within the next 30 days, comma, the clerk or administrator is directed to place such a resolution. It's been driving me nuts that the template from the city attorney had a typo at the end there. Directed to place such a resolution on the agenda of the next meeting of the Sunshine Ordinance Task Force, period. I don't believe it changes any of the intent, but I think it streamlines the language, and as I suspect you'll be adopting this every 30 days or so for the foreseeable future, I think it would be good to have a simpler and cleaner resolution. Unless there are questions, thanks for listening.
Any other public comment?
You had too much time on your hands.
Last call for public comment. Okay, public comment is closed. Member Highland.
Yeah, I just agree with the last speaker. I think it's important to put in the clerk of the committee rather than Cheryl Legge's name, because if she's not there next month and Victor Young does it, then that could be an issue. So I think the clerk would be more encompassing, and I think it's also cleaner to write the Sunshine Task Force and its committees rather than listing them out each time, or list them out the first time but not subsequent times, just to have a cleaner document might be wiser. Thanks.
You're welcome. I think a better term is not clerk but administrator, because that's the official title. But it should be maybe administrator or assistant or I'm not sure, or other agent or other responsible party or something like that. Member LaHood.
I want to agree with Member Highland and with the commenter. In fact, I think all of the edits were very well worded, and if we were to just go back and listen to the audio and follow them in detail, I think that would make it all much simpler.
Hi. Are you waiting for Marie? She here?
Are you? Hello, ma'am, can you please put yourself on mute by pressing *6? Thank you. Okay, so anybody else? Any other comments or adjustments? I agree. I thank the Mr. Popel, public commenter, for the good wordsmithing. I think that it doesn't change the intent, but does definitely streamline it. I would, with regards to replacing Mr. Legge's name, try to find it. Just put the word administrator in there. That still depicts that position be there. But if the administrator is not, present, then it's got to be some other responsible party it's filling in.
This is Victor Young. We could just say SOTF staff.
Okay, that's fine. Thank you for that suggestion. So in the last resolve, it'll be that the SOTF staff, or that the staff of the Sunshine Ordinance Task Force is directed. How about that? Okay. And all the other edits seem fine to me. Okay. No other comments? Ready for a vote? Okay. Please call the roll.
Member LaHood?
Aye.
Member LaHood, aye. Vice Chair Yankee?
Aye.
Vice Chair Yankee, aye. Member Forsley, not present. Member Neighbors?
Aye.
Member Neighbors, aye. Member Highland?
Aye.
Member Highland, aye. Member Stein?
Aye.
Member Stein, aye. Member Wong? Not present. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Chair Wolf?
Aye.
Chair Wolf, aye. Moved by Member LaHood, second by Vice Chair Yankee to approve the resolution.
Okay, thank you. And thank you, DCA Castillo. Appreciate your help and advice on this. Continuing with the approval of the agenda.
I'm sorry, Chair Wolf.
Who's speaking?
It's David Pilpel. I'm happy to provide a marked version of that to Cheryl if that helps you. Thanks.
That's sure. Thank you.
Yes, that would be appreciated, Mr. Pilpel.
Okay. Need to take action on continuing item number 6. There's a lot of background noise. Can everybody please, who's on the phone, please press *6 to mute yourself? I will not continue the meeting until everybody does. It's too much background noise.
This is Victor Young. I'll go ahead and mute all the speakers at this time. And I would also suggest that we continue item number 12 as you referenced.
Yes, for sure. So I will I'll move it. Move to continue item number 6 and number 12 at the call of the chair. Is there a second?
Member Highland here will second.
Okay. Any discussion? Any public comment? If you wish public comment, please press *6 to unmute yourself and let us know. *6. Last call for public comment. Okay, seeing no public comment, are we ready for a vote? Okay, please, no objection, please call roll.
Chair Wolf?
Aye.
Chair Wolf, aye. Member Highland?
Aye.
Member Highland, aye. Member Forsley, absent. Member Neighbors?
Aye.
Member Neighbors, aye. Member Stein?
Aye.
Member Stein, aye. Member Wong, not present. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member LaHood?
Aye.
Member LaHood, aye. Vice Chair Yankee?
Aye.
Vice Chair Yankee, aye. Moved by Chair Wolf, seconded by Member Highland to continue items 6 and 12 to the call of the chair.
Very good. Okay, please call next item.
Item number 2, approval of the minutes from the Sunshine Ordinance Task Force September 1, 2021 meeting. I have a copy of the minutes. If anybody would like to make suggestions.
Members? Any changes or adjustments to the minutes? Okay, is there a motion to approve the minutes? I will call public comment after the motion is made.
This is Member Stein. I'll make a motion to approve the minutes.
Moved by Member Stein. Is there a second?
This is Member Neighbors. I'll second.
Moved by Member Stein, second by Member Neighbors. Is there, let's open up for public comment. Press *6 to unmute yourself and let us know that you wish to speak. *6 will unmute yourself and let us know that you wish to speak. Last call for public comment. Okay, hearing none. Members, any last discussion? Okay, ready for a vote? Hearing no objection, please call roll.
Member Stein?
Aye.
Member Stein, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Forsley, absent. Member Highland?
Aye.
Member Highland, aye. Member Wong? Not present. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Vice Chair Yankee?
Aye.
Vice Chair Yankee, aye. Chair Wolf?
Aye.
Chair Wolf, aye. Moved by Member Stein, second by Member Neighbors to approve the minutes of September 1, 2021.
Okay, thank you. The motion is approved. Please call the next item.
Item number 3, Board of Supervisors Ordinance 201132, Campaign and Governmental Conduct Code, behested payments. Shall I read the preamble, Chair Wolf?
Go for it. Sure.
Effects on the Sunshine Ordinance Task Force members and possible additional proposed amendments to present to the Board of Supervisors based on discussion of this issue.
Okay, members. Some of you are new to this. Some of you are not. In 2017, there was an ordinance created that created some restrictions on activities by public officials, including appointed officials, with regards to fundraising by nonprofits and other types of entities. In that time, it was unclear as to whether the Sunshine Ordinance Task Force was also included in this because of our quote-unquote status and whether we rose to the litmus of what the original ordinance had placed these restrictions on, the type of body we are. We're kind of an interesting, unique body because we were created by the voters. We weren't created by the mayor or the executive branch. We weren't created by the Board of Supervisors, and we're not part of a charter amendment. And because we don't have specific authority to enact policy or to impose penalties or issue permits or what have you, we had asked the Ethics Commission, well, actually one of our members at the time, Dave Moss, had asked the Ethics Commission for an official opinion, which summarily included the Sunshine Ordinance Task Force as he was asking the question based upon his position. He worked for a nonprofit, and several of us also did too. And the results of that were that the Sunshine Ordinance Task Force members are exempt from that original behest payment ordinance. These new amendments have come up, and it seems to include all appointive officers or appointive officials, and it's not clear as to whether the Sunshine Ordinance Task Force is still exempt or whether we have now been folded into these amendments. I have asked Supervisor Haney and his office to provide some explanation, considering he is the author. I heard back from his office today. Unfortunately, they have a conflicting meeting happening right now, so no one can be present from his office that is familiar familiar with the amendments to present. I had further requested, if they weren't able to send somebody, to continue the item until after our November 3rd meeting, so that we had an opportunity to be able to review it, provide any suggestions or a response to the committee, and whether whether they would do so, and give us an opportunity to be able to take action on it and some time to review it. In 2017, when this happened, when it first happened, the first round, it got continued by the Board of Supervisors a couple of times, and part of that was because we requested a presentation. At that time, it was through Supervisor Peskin's office, and his staff had come and gave, very ample access for a question and answer period, so we can get clarity on what the intent of the this legislation is. So with that said, I want to ask DCA Castillo if she has any further information to provide for us. I did ask for some legal counsel to review this, and so Ms. Castillo, do you?
I have reviewed it, but given the fact that the amendment is still undergoing revisions, I do not see anything additional to the language than what you've already stated. I think the difference in what you just, the item that you just raised about employees having to file Form 700, that may be the only thing, to the extent that you've stated that the members do file Form 700, that may trigger a requirement. But so far, it's hard to say what the impact will be without having the final resolution. But based on what the Ethics Commission stated in 2017 in their opinion and their finding, they didn't find that the members of the Sunshine Task Force were required to file or prohibited from, included in the ordinance.
Right. The requirements under the charter for the Form 700 and the the inclusion of the Sunshine Task Force, wasn't that part of the original ordinance also?
I'm not sure. I didn't think I saw that.
Section 1104, right?
Hold on. I don't see that offhand. I don't have that copyright in front of me. But if it was part of the original ordinance in 2017 and there is no change to that, then we would need to look into it further. But I would say if that was part of the original requirement under the ordinance in 2017, and the Ethics Commission found that the members of the task force did not fall into the categories, then that would be true today. But like I said, I would have to see what the final ordinance states.
Okay, very good. Okay, any questions?
And I don't know, I think you referenced it and sent it to us, but I'm not sure if you circulated the Ethics Commission 2017 opinion. That might be worth reviewing for all the members, because they do lay out in their opinion not just their answer, but they go through an analysis of why they determined that the task force did not fall under the category of a administrative or an enforcement body.
Yeah, it
So that may
didn't make
provide
it in.
some explanation.
I agree. It didn't make it into the agenda as I had hoped.
Okay, that's fine. Yeah,
if
but just for
members-
future discussion.
If members are interested, well, we can send that around, and we can send that around, and also make that available on the website for members of the public to review too. There's no, unless somebody has some action or any prepared suggestions to move forward to the author or the committee, the rules committee. We can take that now. Otherwise, I would suggest just forwarding them to Ms. Leger, and then she can forward them to me, and I'll review it with Vice Chair Yankee, and then see about what the plans are from Supervisor Haney as to the future of the amendments at this point. We're kind of in a purgatory area without having any response from them. Okay, hearing none, let's open it up for public comment. Ms. Leger, I'll hand it to you.
Do we have public commenters?
Please
Yeah.
unmute yourself by pressing *6 if you wish to comment.
This is public comment on item number 3.
Any public comment? Please unmute yourself by
David
pressing.
Pilpel.
There you go.
Thanks.
Any other public commenters? Let's see if we can get if there's anybody else we can, so we don't have to keep stopping. Any other public comment? Okay, hearing none. Please wait for Ms. Leger.
Mr. Pilpel, are you ready?
Yeah. Are you all set?
Yep. Go ahead, sir.
Okay. Thank you. So this is on item 3, the board legislation on behested payments. The reference that you made to the Ethics Commission memo, I'm interested in that, whether or not you post it, if you could just relate to me the date of that memo, and if it is already on the website in connection with an Ethics Commission meeting, if you've got the URL or the meeting date, then I can find that. That would be very helpful. I recall a number of things. I recall that the task force is considered a policy body. I was advised long ago, far away, that it does exercise some sovereign powers of the city, and on that basis, the task force is subject to the Form 700 requirements, and I'm trying to remember what flowed from that. That although you have limited decision-making powers, that the powers that are spelled out in the ordinance do confer some powers and duties on the task force, and so taken together, I think you are subject to whatever requirements the board imposes on all officers generally, or on all members of boards and commissions. If there are particular issues that one or more members of this body thinks might impact them with this particular legislation about behested payments, then you may want to suggest an amendment that either carves out members of the task force or applies an exemption to some restriction read broadly, if that makes sense, to others similarly situated that serve on nonprofit boards or have other considerations. Anyway, that's just my recollection. Once again, it's been a long day. I hope that helps. And perhaps, again, if you could give me the date or a website for that memo. Thanks.
Any other public comment? Okay, hearing none. For everybody's edification, I have the item, the Ethics Commission's official opinion. It's a formal opinion. Its item number is OP Oscar Paul -17-001, and the date is printed on it is November 27th, 2017. It's titled Before the San Francisco Ethics Commission in the matter of formal opinion requested by Dave Moss, member of the Sunshine Task Force. By the Commission, Dave Moss, member of the Sunshine Task Force, has requested a formal opinion of the San Francisco Ethics Commission here in the Commission. Now, I'm going to fast forward out of the preamble and go down to the analysis and the conclusions. And I think just the very first result, very first one, it will answer many of the questions that member of the public, Mr. Pilpel, had brought forward. And you can get a little better idea, and everybody else can have it. Again, we'll get it posted on the website, but I think reading this into the record for everyone would be helpful. The question before the Ethics Commission is the Sunshine Ordinance Task Force subject to the behested ordinance? Answer, no. Members of the task force are not subject to the reporting requirement established in Ordinance number 001-17, contained in Campaign and Governmental Conduct Code, here in the code, section 3.610, period. Code section 3.610 provides that, quote, if a commissioner directly or indirectly requests or solicits any charitable contributions or series of charitable contributions from any party, participant, or agent of a party, or participant involved in a proceeding regarding administrative enforcement, a license, a permit, or other entitlement for use, and that list is emphasized, before the commissioner's board or commission, the commissioner shall file a behested payment report with the Ethics Commission, unquote. To determine whether the members of the task force will be subject to the reporting requirements in Code Section 3.610, we must determine whether the task force has been endowed with powers to preside over proceedings involving, quote, administrative enforcement, a license, a permit, or other entitlement for use, unquote. Section 67.35 of the Sunshine Ordinance establishes the task force and enumerates the instances under which the Sunshine Ordinance may be enforced. The task force has been empowered via the Sunshine Ordinance with the following authority. And these are in bullets. Quote, develop appropriate goals to ensure practical and timely implementation of this chapter, unquote. Next bullet, quote, propose to the Board of Supervisors amendments to this chapter, unquote. Next point, quote, report to the Board of Supervisors at least once annually on any practical or policy problems encountered in the administration of this chapter, unquote. Next point, quote, make referrals to a municipal office with enforcement power under this ordinance, unquote. And last point, quote, issue public reports evaluating compliance with this ordinance, unquote. If it goes on, the Sunshine Ordinance does not vest the task force with authority over any proceedings regarding a, quote, license, a permit, or other entitlement for use, unquote. While Section 6730 of the Administrative Code empowers the task force to make referrals to a, quote, municipal office with enforcement power under this ordinance, unquote, whenever it concludes that a person has violated any provisions of the Sunshine Ordinance. The Sunshine Ordinance withholds enforcement power from the task force and defers enforcement decisions to other bodies, period. New paragraph. As a general matter, administrative enforcement is limited to those proceedings which, 1, impact the rights and duties of a particular party, 2, are subject to appeal or other judicial review, and 3, result in deterrent or punitive action that carries the force and effect of law. The Sunshine Ordinance gives the task force no authority to conduct such proceedings. The purpose of the task force is to protect the public's interest in open government and open records. The task force's role in pursuing this purpose is advisory. The task force's primary function is to advise the Board of Supervisors and provide information to other city departments on appropriate ways in which to implement the Sunshine Ordinance. Because the task force cannot have before it a proceeding regarding, quote, administrative enforcement, a license, a permit, or other entitlement for use, unquote, Mr. Moss, as a member of the task force, is not subject to the new behested payments reporting provisions of Code Section 3.610. And by virtue of that, and I'm finishing there, and this is my own notation, and by virtue of Mr. Moss as being a member of the task force, extends to all members of the task force. Okay, any further questions, discussion? DCA Castillo, is there anything you wish to add?
Multi-reading.
I'm sorry, I didn't hear you.
Oh, sorry. No, I think you covered it all by
Okay.
reading the portions of the opinion in the Ethics Commission.
Okay, if anybody's of interest, the last two questions were, and they're very short. Does the Sunshine Ordinance Task Force engage in proceedings regarding administrative enforcement, licensing permits, or other entitlement under the behested payment ordinance? The answer is no. See the above the question, which I just read. And the last one are parties with complaints and other matters before the Sunshine Ordinance Task Force, quote unquote, quote, participants, unquote, and quote, parties, unquote, as described in the behested payment ordinance. And the response from the Ethics Commission is no. See the same response from the question 1. So then their final statement is, as a member of the Sunshine Ordinance Task Force, therefore, Mr. Moss is not subject to the reporting requirements in Campaign and Governmental Code, Section 3.610. This response constitutes a formal opinion by the Ethics Commission concerning the application of the Campaign and Government Conduct Code and the Commission regulations to specific transactions or activities set forth. Reliance on this opinion is limited to the facts presented here. Any change in material facts presented may alter the analysis and conclusion of this opinion, and the analysis conclusions reached in this formal opinion may be affected by subsequent developments in the law, including but not limited to statutes, ordinance, regulations, formal opinions, and case law, period. And that ends the document. Okay, if there isn't anything else, we've had public comment, opportunity to discuss. We'll continue this item to the next meeting. And if there could be a motion to that, I would appreciate it. Entertain a motion to continue.
This is Member LaHood. I make a motion to continue this matter to the call of the chair.
They moved by Member LaHood. Is there a second?
This is Member Stein. I will second that.
So moved by Member LaHood, second by Member Stein. Are we ready for a vote? Hearing no objection, please call the roll.
Member LaHood?
Aye.
Member LaHood, aye. Member Stein?
Aye.
Member Stein, aye. Member Forsley, absent. Member Neighbors?
Aye.
Member Neighbors, aye. Member Highland?
Aye.
Member Highland, aye. Member Wong? Not present. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Vice Chair Yankee?
Aye.
Vice Chair Yankee, aye. Chair Wolf?
Aye.
Chair Wolf, aye. Moved by Member LaHood, second by Member Stein to continue the matter to the call of the chair.
Very good. Please call next item.
Second. Item number 4, file number 21054. Complaint filed by Patrick Monette Shaw against Grant Colfax, Veronica Vian, and the Department of Public Health for allegedly violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and or complete manner. On July 20, 2021, the Complaint Committee requested that the respondent provide the requested records within 2 weeks and that the petitioner report back to the committee. As of August 25, 2021, the petitioner had not received their documents.
Okay, Complaint Committee Chair Schmidt, would you like to offer any opening statement or brief report from the committee?
What I will say is that Mr. Monette Shaw apparently was in the past able to get reports of the type of information that he's seeking now. The hospital made a change in its computer systems. He made a request which seemed to be not anything different than what he had done in the past, and was told that he basically wasn't given the kind of records he was used to getting. In pursuing his claim here, he was told that for some reason at this time, there would need to be a manual search in order to fulfill his request, as opposed to keying in search terms as had been done in the past. And he's heard sort of conflicting information. He believes that it doesn't make sense that the current system wouldn't be able to generate what he needs. So there's a factual question, I guess, as to is it true that for some reason when they made their changes, now it's gone back to a manual system? And then there's I believe you could say there's a legal question, which is that if it's true, if that factual question proves to be if the answer to that question is, yeah, they've gone back to some kind of manual system, then would they need to go to the files and compile what he's looking for, or would that be considered to be a requirement that they create a new document? And so that is somewhat their contention, is that they don't need to create a new document. And there is some, at least state law, that says that in certain cases, you don't need to create a new document. So that's my summary of the situation. I know that Member Stein may have made the motion back at the committee, so I should also see if she has anything to add.
Sorry, I don't have anything to add. I think that was the one meeting that I wasn't able to attend originally. I did have a question about whether in that meeting, DPH had said whether or not they even still use the SF Git Care database, but I don't think I was at that meeting.
As I recall, the motion was to ask them for a report to give us a little more information. Now I'm recalling it was Member Wolf, maybe who Chair Wolf, who made the motion to ask them to fill us in on what exactly is going on, and that they would need to report back to us. And I believe there's been no response in any way.
Thanks.
Okay, thank you very much. I also, just for everybody's edification, I know we usually take public comment at 5 o'clock, but the petitioner had requested a reasonable accommodation to be heard before public comment, and considering the two items before took a little bit of extra time, we're going to continue hearing this item, and then we'll have public comment, general public comment thereafter. Okay, so let's begin our process. We're going to hear from the petitioner first, and then we're going to call for any any witnesses. Then we're going to hear from the respondent, ask for any witnesses from them. There'll be a question and answer period for clarification by the task force. Then we'll hear rebuttals, and the task force will, there'll be I'll entertain a motion. We'll take some public comment after the motion is made, and we'll take action. Okay, Ms. Leger, are you ready?
I am, Mr. Minich. Are you ready to begin?
Yes, ma'am.
And is the respondent here? Is the respondent? Department of Public Health? Is anyone? Yes. Who's speaking?
Oh, yes. This is Christina Padilla. I'm a public information officer at the San Francisco Department of Public Health.
Familiar with the? Are you familiar with the details of this complaint?
I'm somewhat familiar. I do want to preface this by saying that the previous custodian of records, Veronica Vian, she was managing this request, and she left the organization recently in September. So I'm temporarily covering public records until a new person is hired to take her place. And I'm saying that because the extent of my historical knowledge is limited to what was entered in our next request database, and that 4-page document that Mr. Monette Shaw provided, which I read in detail. So I have some history of it, but not everything.
Okay, great. So members, I'm just going to preface this by saying, if you find that Ms. Badillo does not have enough information to provide enough representation for the respondent in response to the complaint, that you might want to consider continuing the item. So just keep that in mind. Okay, so let's begin. Ms. Leger, I'll hand it over to you, and we'll hear from the petitioner, Mr. Monette Shaw first. Thank you.
Mr. Monette Shaw, you ready to speak?
Yes, ma'am.
Go ahead, sir.
I filed this complaint on May 4th, 2021. Despite the 2 supplemental documents I submitted afterwards on July 15th and September 10th, and the chronology document I submitted to you on October 6th to summarize this complaint and add additional information that later became available. The initial complaint remains essentially unchanged, except for the addition of Eric Raffin, Jeff Scarafia, and Dr. Ratana Wongsa as additional individuals responsible at DPH. DPH has provided in the past similar data for at least 7 years, going back to at least July 2006 by providing retrospective data. My initial complaint noted that DPH provided a partial response about out-of-county discharges from Laguna Honda Hospital. DPH has not provided the out-of-county discharges from SFGH because it claimed, I think wrongly, on September 16th, 2020, that its new electronic healthcare record system named EPIC doesn't track out-of-county discharges. So DPH has still not completed this records request by providing the out-of-county discharge data from SFGH. After submitting this complaint on May 4th, I received additional information on June 16th from EPIC Corporation's Media Relations Department, who informed me that EPIC's database contains a module named Patient Flow that captures each patient's discharge location, including the name and address of the facility, the name of the city the facility is located in, along with the type of facility patient has been discharged to, apparently in structured database fields. So I filed my first supplement on July 15th, prior to the complaint committee's July 20th jurisdictional hearing. The complaint committee found the task force has jurisdiction and directed Ms. Vienne and DPH to submit in writing within 2 weeks from a knowledgeable person whether the requested records exist in DPH databases and whether the data could be extracted to comply with California Code Section 6253.9A. Ms. Leger has confirmed DPH did not respond within the 2-week period the complaint committee had requested. Following the July 20th complaint committee hearing, I received a response to a separate but very related records request on August 2nd, containing a thread of 29 emails exchanged among DPH IT staff members. So I filed my second supplemental document on September. Of note, the 29 emails revealed DPH's staff claimed there were no structured database fields, but EPIC Corporation appears to show that there are structured database fields that I showed you in the graphic on page 65 in the full packet.
Sorry, sir, your time's up.
Okay, I will continue in a rebuttal period.
Okay, thank you. I just put a note for the record that Vice Chair Yankee left the meeting at about 4:02 p.m. I think he'll be returning within the hour. Okay, are there any persons or witnesses to provide any facts or evidence in support of the petitioner? Okay, hearing none. Respondent, Ms. Padillo, you have 5 minutes. Wait for Ms. Leger.
Ms. Padilla, are you ready?
Yes.
You may begin.
Thank you. From the files that I have that the previous custodian of records worked on, I see that her response was that because the Department of Public Health adopted a new electronic record system. We do not currently track the out-of-county discharges, and because it was going to be a manual process through the new system, the city's obligation under the Sunshine Ordinance, like the Public Records Act, is to produce public records in its custody. And so there was no requirement that a department construct the document for the request. And that's really all of the information that I have regarding this request.
Does that complete your testimony?
Yes.
Okay, thank you. Are there any persons or witnesses providing facts or evidence on behalf of the respondent? Okay, hearing none. Members, the matter is now with you for questions and answers, clarification. We'll have debate after rebuttals.
What about a rebuttal period to what DPH just said?
Mr. Manette-Shaw, you're aware of our process that we have a Q&A clarification period now, and then when the task force members are satisfied, then I'll call for rebuttals.
Okay.
Can you acknowledge?
Yes, okay, go ahead.
Thank you. Member LaHood.
Yes, thank you. Ms. Padilla, I have a question. You said that this would require some research and a manual assembling of information. If it's possible to do this research, it strikes me that there are responsive documents. These documents perhaps need to be redacted, but couldn't you redact them to only show the requested information? If the information exists in public documents and you can provide it in that format, I don't think you're required to create a new database. You could just provide those documents redacted in such a way to show just the requested information, to show the requested information and redact any information that should be redacted for in light of privacy concerns. Is that something that you think would be possible?
I would like to speak to some of our DPH subject matter experts on EPIC or some of the leadership to understand what that process is like before I give just to give a more informed answer, just because I know it's a manual process, but I don't know what that looks like.
Okay, thank you. That was my question.
Okay, Member Padmanabhan.
So, Ms. Padilla, I don't know if you, so if you're going to ask, we're going to ask questions about EPIC, then could you add this too as to whether Mr. Manette-Shaw is right about whether EPIC contains the patient flow data? And if so, does that not mean that out-of-county discharges or data is present, is there in EPIC? And yeah, could you find the answer for us, Ms. Padilla?
Yes, I can.
Okay.
Yeah.
The second question is also is for Mr. Manette-Shaw. You had written that that you received an email that was heavily redacted from Ms. Vian. What was in that email?
I don't know, obviously, because I can't see under the redaction, but the timing of it was interesting. I submitted it late in the afternoon or evening on May 4th. And on May 5th, I received a receipt in email that DPH Miss Vian had in fact opened and read my sunshine complaint that I filed the day before on May 4th. And it was somewhat curious that they chose to redact part of her email to other DPH IT staff. So the coincidence in timing was really strange because I had never, ever received any redacted information in the 7 or more years I've been requesting similar data. And in those 7 years, they never had a need to redact patient information that may have violated HIPAA, patient privacy protections. This is strictly aggregate data. It is not about any individual patient discharge location. And consistently over 7 years or more, DPH has provided the same information without any allegation that it would require redacting patient confidential information. And I might add that the documents I have submitted to you addresses the fact that if a patient at Laguna Honda Hospital or SFGH has been hospitalized with room charges, how does DPH know when to stop the billing for those room charges after the patient has been discharged if their electronic record system doesn't know when the patient is discharged to? They have been barking up the wrong tree, obfuscating the issue by saying that they have difficulty matching up zip codes at the time of discharge, when in fact, Epic Corporation has indicated there are structured database fields that list the name of a city a patient is discharged to. It's in Epic, it's there, but the IT staff 29 email exchanges never addressed why they couldn't look in the patient flow module that contains the discharge disposition data that Epic Corporation claims exists, and they've never tried to address why they are suddenly unable to track this when they've been providing it for over 7 years. I can't believe they've spent $164 million on a replacement electronic healthcare record system that doesn't know where the patient is or where to send the bill to collect any kind of insurance or reimbursement for the hospitalization. This is completely ridiculous.
So this leads me to my last question for Ms. Padilla, which is that do you know of other databases that are in use?
I'm sorry, can you repeat that?
Do you know what other databases are in use other than EHR or Epic? To track patient data.
I can add that to the questions to ask our subject matter experts for Epic.
Okay.
I'll call upon myself. So, Ms. Padilla, is it Padilla or Padillo?
Padilla with an A.
Padilla, I'm sorry. Okay, just want to make sure I'm pronouncing it right. So at the time, the complaint committee had made this request that the respondent provide either in person or in writing from a knowledgeable person of this database and of the data when the data to provide when the data was transferred from the old to the new system, and if the information that the requester requested is contained in the new database. That's the first part. Was that satisfied?
No.
I don't believe it was.
Okay. The second part is, and whether the information is extractable from either database for the period of time that the requester made the request, and provide that in writing within 2 weeks. Was that satisfied?
I don't believe it was either.
Okay, thank you. Any other questions, clarifications? Okay, are we ready for rebuttals? Okay, seeing no objection, we'll hear from the respondent first on rebuttal for 3 minutes, and then the petitioner. Ms. Leger, I hand it over to you.
Okay. First the petitioner, you said? I thought.
No, first the respondent, then
Yeah.
the petitioner.
Yeah. Ms. Padilla, are you prepared?
I'm here, yes.
Okay, I'm going to start the timer. Go ahead, ma'am.
It appears to me that we owe the requester, Mr. Monet Shaw, either the responsive records if they're available within EPIC, which I can confirm with our subject matter experts, or the documentation in writing from the subject matter experts, whether the records are contained in EPIC. I know there's some questions we have at hand, and that's something that I can work on. And that's all I have.
Okay, thank you very much.
Thank you.
And now the petitioner. Please wait for Ms. Leger.
Patrick, are you ready?
Yes.
Go ahead, sir.
I have tried my damnedest to inform Chair Wolf and the task force that this does not involve migrating records from old databases to new databases. The time frame that I've been looking for this data should only have been entered into EPIC. And it's disheartening that we now have another public information officer who is not, admittedly, a subject matter expert. She doesn't know what she's talking about. And the data exists in EPIC. They don't need to export it or anything else other than write a query looking for the name of the city of the facility a patient is discharged to. It doesn't violate HIPAA. It is not something protected under patient confidentiality. They've been providing this for over 7 years, and I can't believe they paid $164 million for a database that can't do what the old database did. This is ridiculous.
Okay. Okay, thank you very much. Does that conclude your rebuttal?
Well, there's lots more I'd like to get to, and about the fact that knowledgeable staff have not appeared at all in any of these hearings, and that DPH is simply stonewalling and snowing the task force. The data is there. Epic Corporation admits the data is there. It's just that the IT staff got stuck
30 seconds, sir.
whining about zip codes instead of focusing on the discharge notes.
Maybe not.
Can you please stop the clock? Victor, can you please, we can't do that when we're going to cut the other folks off. Can everybody please, if you're not part of this, party to this, please press *6 and mute yourself. Lots of background. Thank you. Okay, please continue with the clock. Thank you. Mr. Manette-Shaw?
What?
You can continue for the rest of your time. I'm sorry.
Okay, I'm not sure what else to say. That the claim that DPH now needs to go back and consult with its subject matter experts is completely ridiculous. The task force should direct DPH to produce the records within the next 5 days, and the task force should order DPH to work with Epic Corporation to figure out how to write a database query to get at the records that have got to be in that database. How do you stop billing? How do you hand a patient discharge notes with their list of medications and do any kind of post-discharge follow-up of patients if you don't know where the fuck that they're at? This is nuts.
Okay, Mr. Manette-Shaw, please watch your language. Thank you.
You need to direct DPH to contact Epic's technical support staff to figure out how to write this query. The data is there. It's in another Epic feature called Care Everywhere. If you go to the hospital, like I did a year ago, you're handed a 13-page or more document when you are discharged. It's all tied into records in a patient's chart, and if they're not putting it in the chart, then they never had the patient. It didn't happen. If they don't know where the patient is discharged to, presumably the patient is still there, and the billing is going to continue until they figure out when and where they discharge the patient to.
Okay.
This is not rocket science.
Okay, I think we're over time. I have not heard Ms. Leger call for the end of the time, but I think we've heard enough. Thank you very much. Members, the item now is with you for deliberation and for action. Member Padmanabhan.
Yeah, I'd like to go ahead and make a motion.
Go ahead.
So I move to find the Department of Public Health violated Administrative Code, Sunshine Ordinance Section 67.21B for incomplete production of records, 67.21C for failing to provide assistance, 67.27 for failing to provide justification for redaction, and maybe 67.22B for not sending knowledgeable staff.
What about willful failure?
No, Mr. Manette Shaw, please do not speak out of turn. Please, your time, we've had your time, we have your records. It is up to the task force now to make their decision. Thank you, Member Padmanabhan. So we have a motion for 6721B, 6727, 6721B and C, 6722B, and 6727, right?
That's right.
Okay, great. Is there a second?
I'll second. Member Schmidt?
Moved by Member Padmanabhan.
Will that include an order that all this be produced? I'm not sure if I heard that.
Member Padmanabhan?
Yes, I'm happy to include that.
Good motion. Second.
Okay. Addition that if records be produced, is there a time frame?
5 days.
Please, Mr. Manette Shaw, I'm just going to mute you if you're going to continue to speak out of turn. I'm not going to tolerate it. Members, is there a time frame? So generally, when we issue orders of determination, our complaint procedure requires a response within 5 days. So
then in that case, yeah.
So 5 days?
5 days.
And I will add that this will be monitored by compliance and amendments. Is that okay with you? Okay, great. So I'll repeat the motion. Okay, great. So this was moved by Member Padmanabhan, second by Member Schmidt to find a violation, the Department of Public Health in violation of 6721B, 6721C, 6722B, 6727, with the reasons behind those that can be retrieved later, and that the records be produced within 5 days, and that this be referred to compliance and amendments for monitoring. Okay, members, any further discussion or debate before I open a public comment? Okay, hearing none, we can come back to that. I'll open it for public comments. So public comment for anyone other than the parties. Please
I would like to make public comment.
Please unmute yourself. We hear you. Please unmute yourself by pressing *6 and wait for Ms. Leger.
I'm waiting to make public comment.
Oh, okay. We will call you speaker number 1.
Okay, can I start?
Just a moment. I want to see if there are other public commenters. Okay, Chair Wolf, I'm not hearing other public commenters. We will begin with speaker number 1. Ma'am, are you ready?
Yes. My name is Dr. Teresa Palmer. I'm an ex-employee of UCSF, and I'm still a referring physician to UCSF. And I wanted to note that there is a pressing public interest in knowing who we are transferring out of county, because it's an important measure of gaps in services in San Francisco. If we have to dump people out of county, it means that we can't take care of them in county, and we need to know that. I am very familiar with Epic. I've used it at Kaiser, at UCSF, and at Sutter, and I remain a referring physician for 2 of these systems. There is clearly a data entry about discharge that could be, and location of discharge that could be found by writing the proper data request. And my feeling is that the folks at the Department of Public Health just don't want to know who's going out of county, and or they're too overwhelmed from COVID to try to find out. But we do need to know who we're dumping out of county. And I think Mr. Manette Shaw is extremely right. He's been working on this information for years. We have multiple supervisors who are interested in writing legislation to have hospitals track who's being discharged out of county. And we need to start with our own house. Thank you.
Any other public comment? Last call for public comment. Okay, public comment is closed. Members, are we ready for a vote? Hearing no objection, please call the roll.
Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member Forsley, absent. Member Neighbors?
Aye.
Member Neighbors, aye. Member Highland?
Aye.
Member Highland, aye. Member Stein?
Aye.
Member Stein, aye. Member Wong? Member Wong, absent. Member LaHood?
Aye.
Member LaHood, aye. Vice Chair Yankee?
Absent.
Absent. Chair Wolf?
Aye.
Chair Wolf, aye. Moved by Member Padmanabhan, seconded by Member Schmidt, to find that the Department of Public Health violated 6721B and C for incomplete production of record, 6722B and 6727 for failing to provide justification for redaction, and that the records be produced within 5 days and to be monitored by the Compliance and Amendments Committee.
Very good. Okay, please call the next item.
Thank you.
Before you move on, I just want to state that 5 days is from the issue of the order of determination and not
Yeah.
5 days from today.
Yes, thank you.
No.
Yes, that's the way our complaint procedure is written. I'm
That
sorry.
could take months.
No, it won't take months. Please call the next item.
Item number 7, file number 20100, complaint filed by Winship Hillier against the Behavioral Health Commission.
Oh, no, Ms. Leger, you missed public comment, general public comment.
Sorry, I apologize. You're absolutely right, I apologize. Item number 5, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the task force jurisdiction, but not on today's agenda.
Okay, if you wish to speak in general public comment on items not on today's agenda, please unmute yourself by pressing *6, and I'll hand it over to you, Ms. Leger.
Sullivan. Winship Hillier.
Do we have other public commenters?
Winship Hillier?
I got you, Mr. Hillier. I'm just trying to see if there are other public commenters. Okay, we will begin with Mr. Sullivan. Mr. Sullivan, are you ready?
Yes.
Go ahead, sir.
The Sunshine Ordinance requires that public employees give accurate and truthful information. I'm going to work backwards into this reasoning because I think it will be easier to understand. Section 67.22, release of oral information, B. This section shall not be interpreted to curtail existing informal contacts between employees and members of the public when these contacts are occasional, acceptable to the employee and the department, not disruptive of his or her operational duties, and confided to accurate information, not confidential by law. So informal contact, employees must give accurate information. Kind of sounds like the task force should hold informal hearings. A broad and logical interpretation of this is that employees must also provide accurate information in formal situations. It seems the assumption of the ordinance writers. I went looking for some language to back it up. Big things are usually at the top. Section 67(1), finding and purpose. B, election officials, commissions, boards, councils, and other agencies of the city and county exist to conduct the people's business. People do not cede to these entities the right to decide what the people should know about the operation of local governments. Also, no is used in 67(1)D and the Brown Act 54950. Dictionary.com, no, to perceive or understand as fact or truth, to apprehend clearly with certainty. Merriam-Webster, no, to be aware of the truth or factuality of, be convinced or certain of. In my opinion, the Sunshine Ordinance and the Brown Act requires government employees to provide accurate and truthful information at hearings, regardless if they are not under oath. The Sunshine Ordinance goes further in section 6722E in protecting public employees from disciplinary action for being accurate, speaking the truth, and disclosing any public information or a public record. Thank you for your time.
I would like to speak.
Mr. Hillier, are you ready?
I'm ready, Ms. Leger.
Okay. Go ahead, sir.
Thank you, Ms. Leger. I don't need a warning because I'm timing myself. Ladies and gentlemen of the task force, I'm a frequent flyer and hoping to continue to be, well, not really hoping, but I'm anticipating continuing to be. I would like a reference to staff or other resources for factual information regarding the following question. Often I create complaints that have multiple attachments, multiple files, agendas, minutes, and emails, and other documents. They're all combined into one complaint. And usually what I do is I go to FedEx to do this, and while the clock is ticking away at 65 cents a minute, I put these files together into one file, and I put bookmarks on each of the attachments so you can easily navigate to each of them using the bookmark plane. I also sometimes put in highlighting, and that's very, very important sometimes because some of the documents are long. The emails can be long, they can be lengthy. It's very helpful to have highlighting. The minutes can be long, the agendas can be long. However, I noticed that when these complaints are sent around to the task force, and also I think when they're sent out to the respondent, that both of those kinds of information, the highlighting and the bookmarks, are stripped out. And I would like to know whether the task force at least has access to the original PDF filing that I produced, and whether the complainant or the respondent can also have access to that. But mainly it's the task force. That's a big mystery. I don't know what you people have access to. If you only have access to what's on the public record, i.e. what you get when you click through the agenda to the PDF with the P numbers on the bottom, stamped on the bottom, if that's what you get, if that's all that you have access to, then you're losing all that information. And I don't have to, I shouldn't spend my time and my money putting it in the first place, and B, I'll find some other way of drawing your attention to the appropriate information or putting page numbers for the attachments and so forth. So I'd like a referral to staff or other resources. I've got you, Cheryl. I'm timing myself for factual information. Back to you, Madam Clerk.
Did we have
I
another?
would-
Did we
I
have
would
another
like-
public comment?
I would like to speak on Patrick.
Are you ready, Patrick?
Yes.
Go ahead, sir.
I cannot begin to express my disappointment with the task force. I have been engaged in filing sunshine complaints, supporting complainants, all the way back to Alan Grossman. You remember Alan? He was a brilliant lawyer. And I can't believe that after 20 years of being involved with the Sunshine Task Force, suggesting revisions to the language of the Sunshine Ordinance and rooting for the task force to be a truly independent body of City Hall, that you are still demonstrated today that, as Mr. Sullivan indicated, the task force is being snowed by public information officers who are not knowledgeable technically about the sunshine complaints filed against their city agencies. They waltz into your hearings and they lie to you. They don't present you with accurate information. They throw sand in the eyes of the bull, and you folks swallow it. Hook, line, and sinker. What you just got out of GPH on my complaint is complete bullshit. I don't care if my First Amendment use of the vernacular annoys members of the task force, but there you have it. You just got snowed. That data is available in Epic, in their database. They should never have spent $164 million on a database that doesn't know where their patients have been discharged to. The Sunshine Task Force is becoming, in my eyes, a huge disappointment in keeping our government open for we, the people. We do not cede to DPH or anybody else being able to come in there and snow the task force and lie to you through their teeth.
So your
Thank
time
you.
is
Thank you. Any other public comment? Last call for public comment. All right, I'll just say to the last speaker that, first of all, your comment, is on an item that was on our agenda. So not appreciative of that, respect. And we did find it in your favor on 5 counts. So that ends public comment. I'm not hearing anybody else stepping up. So public comment is closed. Let's go to the next item. Thank you.
Chair Wolf, item number 7.
Item number 7, yes.
Yes. File number 20100, complaint filed by Winship Hillier against the Behavioral Health Commission, formerly known as the Mental Health Board, for allegedly violating Section 67A, failing to post the agenda 72 hours in advance, and failure to provide a description of each item of business. 67.7B, failing to post documents on the website or make available to the public. 67.7D, failure to take action on any item not on the agenda. 67.7G, as in George, failing to allow public comment. 67.9A, failure to post relevant documents on the internet. On June 8th, 2021, the Education Outreach and Training Committee heard the matter and moved to find jurisdiction. The records are public and refer the matter to the task force to consider the following violations. 67.7 for failing to comply with agenda requirements, 67.15 for failing to allow public comment, and 67.29 for failing to maintain and update their web page and access.
Okay, I apologize, folks. There was supposed to be an item before this to determine whether items number 7 and 8 should be combined. And that has been omitted from the agenda. There was after reading both of these and seeing that they were heard by 2 different committees inadvertently, I contacted the chairs and confirmed that they did confirm it. So I want to entertain a motion to combine the items, and we can get some explanation why.
I'll second that motion. This is Member Highland.
Okay. So note that I made the motion to combine items 7 and 8. Second by Member Highland, and I'll defer to both Member Highland and Member Schmidt, who are chairs of respective committees that heard this item, for any presentation or comment or report.
Member Highland,
go ahead.
Go ahead if you want, or else I'll take a shot at it. Our case may have been the more global of the two from looking at this.
I agree. I think a lot of our items come up again in yours, so I think we're a subset of yours. But what members might want to do is, as Member Schmidt is presenting, is take a look on the next item, item 8. Look at the attachment. Look at page 449. There's a list of all the complaints there, so just to give you that sort of that global perspective as to what we're dealing with here, if you haven't already. But that will kind of, I think, start us out at a 33,000 foot vantage point on this, and then kind of drill down to where we need to get to. So go ahead, Member Schmidt.
Sure. In terms of the motion, at least, which certainly I can understand value in combining these two. The case that was heard before the EOTC, Chair Highland, seems to be limited to approximately 7 claims arising out of a July 15 meeting, and they're all meeting violation claims. The second matter, which is in our committee, the complaint committee, there's actually enumerated, I think, 103 claim violations by the claimant, which would encompass pretty much what was included in 20100. I'm not sure if they match up item by item, but you take that July 15 meeting and then several other meetings, both before and after, and it's the same types of claims. There's about 7 or 8 provisions in the ordinance that are cited. I think that the argument in the presentation would be on the same issues. And I believe that our ruling would probably be in the first case, it would be pretty much dictated by what our ruling would be in the second case. In terms of the types of claims, they're all about basically how the meetings are being run at the Behavioral Health Commission, how they're posting their agendas, whether they're putting up certain documents. I mean, there's a litany of claims, as you can see. The complainant has been extremely helpful in detailing all these claims and even enumerating them for us to the point where I think that the Behavioral Health Commission, we haven't gotten too much of a response from them, although it's a pretty massive set of allegations that are here. So with that in mind, I think that we might as well combine the two and hear them together. That's all.
Okay, great. Just want to recognize Vice Chair Yankee is returned to the meeting at 5:55 p.m. I have a question for either or both of you. Both of these complaints involve meeting issues around open meetings?
Yes.
Okay. And while the second item 20143 has more reports of the violation the violations are more or less the same, or the allegations of violation are more or less the same between the two?
Yes, with maybe one or two sort of random ones that are thrown in. I think I count about 8 different sub provisions that seem to be implicated. And so there's a couple more on top of what were considered in 20100.
Okay, so as you were saying, 20100 is somewhat of a subset or inclusive of the similar or same allegations as in 20143.
Yes.
Okay, great. Member Highland.
I was just going to echo that basically I think any violations, should we find any in 20143, would more than amply cover 20100 would be my feeling.
Okay, great. All right, since we have motion on the floor, any other members, any other discussion or questions on combining items 7 and 8? So these are files number 20100 and 20143. They fit our, just for everybody's edification, they fit our criteria for combining, which are would be have the same nucleus of facts, have the same complainant and respondent, have the same complaint and or administrative codes in question. Issues or violations must be within 90 days of submission of the initial complaint. And so with that, let's open up for public comment, and this will include the parties. Parties may speak on this combining of the two. I will ask that the parties be, if they wish to speak, that they speak first. And so that would be Mr. Hillier and the respondent, whoever's representing the commission.
Okay, let me know when you're ready.
Do we have a respondent who'd like to speak?
Can you hear me?
Yes, we can. Is
Hello?
that Mr. Gray?
Can anybody? Oh, okay. Yeah, this is Jeffrey Greer, Executive Director.
Okay, Mr. Hillier first.
Yes, I know. Mr. Hillier, are you ready to speak?
Yes,
Go ahead, sir.
thank you. I'm only speaking on the motion to combine. Just wanted to say I was very careful not to duplicate any claims between the two complaints. They're all distinct claims. However, the 20143 covers the July 15th, 2020 meeting, which is also the exclusive subject of the 20100. 20143 also raises some records issues. We did request some records, and there were some violations of specifically the higher numbered divisions of the Sunshine Ordinance. Back to you, Madam Clerk.
Ms. Leger?
I'm with it. Just a second. Mr. Greer, are you ready to speak, sir?
Yes, I am.
Go ahead.
I just would like to echo that I don't really have a problem with the combination of the two files. There are distinct differences, as the complainant pointed out, which I will get into as we get into the further explanation. I do have public comment from a commissioner that can't be present. I don't know if this is the forum or time, but just to kind of echo the sentiment, I don't have a problem with the combination of the two files.
Okay, thank you. Before we take additional public comment on the combination, members, do you have any questions for any of the parties? Okay, hearing none, let's continue with public comment and then we can come back to discussion.
Do we have other?
Can I present public comment on behalf of a commissioner that cannot be present?
If it pertains to the combining, if it's specific to the merits of one or the other case, okay. So hold off on that until till we get into the meat of the case. Thank you. Any other public comment? Okay, members. Any other discussion? I find Mr. Hillier's comment to be somewhat compelling. It seems to have been deliberate in making these separate. I do have some concerns that they, it's kind of, we don't allow duplicative complaints. That we would prefer and generally accept complaints about the same parties around the same kind of issue, whether it's a meeting or the same documents, and to have all the issues be contained in that one complaint, because it sets a precedent, and that's why we created the combining provision in the complaint procedure. Any other discussion or debate?
Member Highland here, Chair Wolf. Not quite sure what side of the line you're falling on with that comment. What I heard from Mr. Hillier is, yes, he had different things that he put into different complaints. but he also agreed that they would be covered by the same parts of the Sunshine code. So I kind of read his response as he was okay with the combination. That's how I read it.
Okay, that's fine. All right, are we ready for a vote? Okay, hearing no objections, please call the roll.
Give me a minute. Chair Wolf?
Aye.
Chair Wolf, aye. Member Highland?
Aye.
Member Highland, aye. Member Forsley, absent. Member Neighbors?
Aye.
Member Neighbors, aye. Member Stein?
Aye.
Member Stein, aye. Member Wong?
I did not hear any of this item, so I don't feel comfortable voting. I just showed up 3 minutes ago.
Okay, so if you cannot make a vote on it, then we'll ask you to step out of the room.
Okay,
and
will do.
And
I'll
remain
come back.
absent. Okay, because we can't take abstentions.
Okay, should I come back in 5 minutes?
Come back in like 3 minutes.
Okay.
Yeah.
Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member LaHood?
Aye.
Member LaHood, aye. Vice Chair Yankee, were you present for the discussion?
Yes, aye.
Member Vice Chair Yankee, aye. Moved by Chair Wolf, second by Member Highland, that after reading the agenda and seeing both matters of items 7 and 8 were heard by different committees, and the motion to combine the items has passed.
Okay, thank you. All right, so we're going to hear both these items as one. You can let's start by reading, Ms. Leger, if you can read both of the preambles of the items, because they are written differently on the agenda, and then we'll begin our hearing process.
When you say preambles, do you mean that the description under each item?
Yes.
Okay. Item number 7, file number 20100, complaint filed by Winship Hillier against the Behavioral Health Commission, formerly known as the Mental Health Board, for allegedly violating section 67(7)A, failing to post the agenda 72 hours in advance and failure to provide a description of each item of business. 67(7)B, failing to post documents on the website or make available to the public. 67(7)D as in dog, failure to take action on any item not on the agenda. 67(7)G as in George, failing to allow public comment. 67(9)A, failure to post relevant documents on the internet. Item number 8, file number 20143, complaint filed by Winship Hillier.
Oh, wait a second. Please read the italics.
All right. Okay.
Thank you.
On June 8, 2021, the Education Outreach and Training Committee heard the matter and moved to find jurisdiction, that the records are public, and refer the matter to the task force to consider the following violations: 67(7) for failing to comply with agenda requirements, 67(15) for failing to allow public comment, and 67(29) for failing to maintain and update their web page and access. Item number 8, file number 20143, complaint filed by Winship Hillier against the Behavioral Health Commission for allegedly violating Administrative Code section 67(7)A as in Apple by failing to post the agenda 72 hours in advance of the meeting and failure to provide a description of each item of business. 67B, B as in boy, failing to post documents on the website or make available to the public. 67-7, G as in George, failing to allow public comment. And failing to include notices, rights under the Sunshine Ordinance on the agenda. 67-7H, failing to include contact information and the administrator's name on the agenda. 67-9, A as in Apple, failure to post relevant documents on the internet. 67-15, C as in cat, failing to allow public comment. And 67-21, B as in boy, failing to make files available to the public. On August 17, 2021, the Complaint Committee found jurisdiction that the records are public and referred the matter to the task force.
Okay, great. Thank you. And I'd like to recognize Member Wong at 6:12, I think. Okay, great. Now let's go to both chairs of EOT and complaints. Is there any presentation or report that you'd like to make with regards to this item? And just before you begin, for Member Wong or anybody else that joined us late, we've agreed to and approved to combine items 7 and 8, file number 20100 and 20143. Thank you. Continue.
I believe Member Schmidt kind of gave a pretty good macro look at what this item was about. So other than the 3 instances that we found in the first case, I think we kind of have to get into the meat of it before we discuss any more. But it certainly appears from looking at the information that there were violations. I've read through the respondents' both chronology and response. They obviously had some technical errors. I think they're admitting to some of the violations, so maybe that might be a good place to start, Member Schmidt. The ones that they are acknowledging, and we can branch out from there if we like.
Agreed. Yeah, it does look like at least we have agreed violations, and you'll probably hear more about that from the parties. I'm not quite sure if we will end up wanting to do anything other than group things, maybe group them per provision and decide which of the provisions that are alleged or which of the provisions we think apply are violated here. I will note 2 things that I did not mention earlier. One is that, yeah, we did hear from the complainant, and who did note that among the 103, there's, I believe, 1 or 2, possibly 3 allegations regarding documents as opposed to open meetings, although the document claims are intertwined with the meeting's allegations. And so on my list, I see 21B and 29 too. So those may be part of what we're going to be looking at here. The second thing I wanted to note is that the complainant did include a lot of discussion about quorum issues. And since, Chair Hyland, his committee, my committee, we looked at these things. I thought I would just say that I don't think that the quorum questions and the quorum discussion is really going to play much of a role here. I tried to get a sense of whether there was some way in which these quorum, the quorum discussion that we got from the complainant would somehow tie into what we're deciding here today, and I don't think it does. You know, someone may think otherwise, but I believe that we generally don't decide quorum questions here. I may be wrong about that, but it also didn't look like we had any kind of sort of interplay between a quorum question and the kind of questions that we'd be looking at here today.
Well,
with that,
quorum is based upon the Brown Act. It's described in the Brown Act, so it definitely is, and quorum is in the Sunshine Ordinance. So I believe it is within our jurisdiction
to decide whether there was a quorum from meetings.
Sure. If a meeting happened and there was not quorum, then the validity of whether the meeting is in question. That's within our jurisdiction. Absolutely.
Okay. Then. Okay. Let me. Okay.
We can discuss it later, and we can hear.
Yeah. Let's see if we think there's anything that the quorum seems to play into.
Okay.
Yeah, I may be definitely overlooking something, but yeah.
Okay, great. So let's move ahead. We'll start with and I want to say that and I'm sure the petitioner will point it out. I've noted that on page 334, that would be under file number 20143. That there's very lengthy. It goes on for pages. That's not a judgment. I'm just noting fact. It goes on for pages. The number of claims or the number of allegations. So that might be helpful as we move along here. And I would ask for either parties to please, since we're trying to keep our meetings timely, if there's specific pages or areas within the record, please do point them out by the page numbers printed on the PDF itself. If there is no printed page number, please refer to the PDF number. So it'd be like 6 out of 132 kind of thing that's in your PDF reader. Okay, we're going to start with the petitioner. We'll have 5 minutes to make a presentation. I'll hand it over to Ms. Leger.
Mr. Hiller, are you ready?
I'm ready.
Okay.
Thank
Go
you,
ahead.
Ms. Leger. I'm sorry.
Go ahead.
Okay, thank you. I don't need a warning. I'm timing myself. Ladies and gentlemen of the task force, I ask for your indulgence to raise and not raise. Hello? I'm hearing a lot of background noise. Can I start over,
we can
please?
hear you. We can hear you. You can start over.
Okay, thank you. All right, so I'm starting over. Ladies and gentlemen of the task force, I ask for your indulgence to raise an issue not raised in either of the complaints. With respect to the July 15th, 2020 meeting, we said that there were 11 members of the commission present, and left it at that as far as whether it was a meeting. After further research, starting with the third complaint, we picked up the idea, we understood, we studied the law, and really, the governing law for the commission does not allow holdover service. And when you take out those holdover members, there were only 3 commissioners present at the July 15th, 2020 meeting. So if this task force adheres to its precedent, which is that SF Charter Section 4.104B applies to the commission, and that the word member in 4.104B means position, office, vacancy, or seat, then there would be 17 members of the commission, and there would be 9 of them would have to be present at a meeting in order for a meeting to occur under the open records laws. Obviously, there weren't 9. So I'm asking you to raise, to deal with this issue now, because if you just reach through to the merits, and then we get on to my third complaint where we take the correct statute, the correct point of view, and then you rule as I just described, well, then we will have wasted all of our time today together reaching the merits issues when this task force had no jurisdiction. And just to clarify, we do not capitulate. We do not forfeit our complaint. We actually want to challenge you and argue you off of your precedent. 4.104B does not apply to the commission. We think we have an unbeatable argument to that effect. It's included in the record. And even if it did, the word member therein does not mean position, office, vacancy, or seat. Okay, so moving on, we promised you legal authority to support the proposition that the words in the statute have their plain and common sense meanings, and that should be used in interpreting the statute. The authority is Jackson versus LegalMatch.com, Volume 42 of California Appellate Reports, 5th Series, pages 760 and 771, decided in 2019, opinion authored by Justice Brown, and I quote, "We must rely on a statute's plain and common sense meaning, unless the statute specifically defines the words to give them a special meaning, ... end quote, citation omitted, square brackets added, quotation marks omitted." We also cited a number of sections of California codes for other boards and commissions to show you what governing laws are like as far as holdover service. Some of them allow holdover service, some of them prohibit it. We didn't cite any that make it optional, which is what the commission thinks applies to them. When it's optional, there needs to be explicit language in the governing law that says that holdover service is optional at the discretion of the member. And some examples we give are Title 52 of the United States Code, Section 30106, Subdivision A2, capital B, and Title 39 of the United States Code, Section 202, Subdivision B1. And with my remaining time, I'd like to clear up a couple of errors in the documents that we submitted, appearing in both files. We said P429, the supplement to 2.100 and 2.143 at page P430, the paragraph just before the logic table. It says if Charter Section 4.10, that should be 4.104B, applies, and the word member in it means position, office, vacancy, or seat. Or if Charter Section 4.10B does not apply at all. Okay, that last, I got you, Cheryl. That last clause should be deleted. I apologize very badly. I mean, you know, there's a reason why that's there, and it's a mistake. And also on the 2 pages forward from that, this part about quorum, just delete that whole thing. What matters is a majority of the members present. The word quorum is occasionally used in the open records laws, but I think that's what it means. Back to you, Madam Clerk.
Okay, are there any persons or witnesses to provide any facts or evidence on behalf of the petitioner? Hearing none, respondent, Mr. Greer, you have 5 minutes. Wait for Mr. Leger.
Okay.
Mr. Greer, are you ready?
I am, if you can hear me.
Yes, we can. Go ahead, sir.
Okay, in the interest of time, I'll try to just dive right in. Mr. Hillier is trying to call into question the general calculation of quorum by invalidating holdover. First of all, it's been advised to me through City Attorney, the Behavioral Health Commission is not a charter commission. It's therefore not subject to holdover limits under Charter Section 4.101.5. The Behavioral Health Commission stay until their seats are reappointed. I have been vigorously working with the supervisors and the Board of Supervisors and their Rules Committee in order to fill the rest of our seats. Moving forward to some of the other items, specifically classified under 20100, because up until now it was considered two separate. 67.7A, failing to post 72 hours agenda. This is not true, as evidenced by the attachments in Mr. Hillier's own presentation. This was timely posted. Posting time can only be validated by the DPH IT services team. Number 67.7B, failing to post documents on the website and make available to the public. This is not true also. As you can clearly see, the document can be viewed by anybody going to the DPH website. 67.7D, failure to take action on any item not on the agenda. If you look into this particular item, action was taken on July 15, 2020 under items 1.2C and 1.2D. Action was taken as evidenced in the minutes. 67.7G, failing to allow public comment. 5 public comment sections are clearly posted on the agenda. In the agenda, an opportunity was given for public to fully respond. 67.9, failure to post relevant documents on the internet. This is not true, as all relevant documents are timely posted with the support of the DPH IT team and services. As we go, somebody's talking in the background. As we move on to the other section, 20143. In a brief mention, primarily the issue is the Behavioral Health Executive Committee meeting. This is what most of these complaints are, 67.7A and all the way through D. It is my contention that meeting never occurred. I went all the way back. I exhumed documents from the DPH IT filing. The actual person who received and does the filing on that particular date that would have been present for the July 6th meeting contends and in writing that there was no document submitted to pre-posted either minutes or agenda for a meeting that was theoretically to occur on July 6th. Now, I must say that during June, July, and August was a transitory team for most city entities. It certainly was for the Behavioral Health Commission, as we were transferring from live meeting to teleconferencing to Zoom. All evidence from my position, as I assumed my post on February 8th, 2021, every research piece that I've looked into, there is no evidence that a meeting occurred on July 6th, 2020. So thereby invalidating many of Mr. Hillier's claims on that regard. As you can see, most of these do overlap and they fall upon each other. I would like to take the time to address each and every one, but in the interest of time, I think I will stop right now.
Okay, thank you. Are there any persons or witnesses providing facts or evidence on behalf of the respondent?
I do have a written testimony from an individual that couldn't make it today. I'd like to read what she had to say, if that's okay.
Are they an appointed commissioner?
They are an appointed commissioner.
Okay. If there's no objection from any of the task force members, I'll allow it.
May I make a suggestion, Chair Wolf?
Yes.
Yes, that we also asked Mr. Greer to submit that statement by email if he can.
Okay, thank you.
Oh, do you want me to submit it by email?
If it's a written public comment, sir, it will be posted in full on minutes.
Oh yeah, I can submit it I can submit it. It's written.
Okay. Let's
I can
do
also
that.
read it. It's just it's less than a paragraph.
Again, it's my suggestion that it be read into the record in this particular section of witness and any other interested persons. That commissioner will become a party, but the commissioner is already party because the complaint is against the commission anyway. So
Exactly.
members are if there's any objection, please speak up. If there isn't, then I'll allow it. Okay, I'm going to allow it. You may proceed, Mr. Greer. Again, 5 minutes. Wait for Mr. Leger.
Mr. Greer, are you ready?
I'm ready.
Go ahead, sir.
Okay. This email is from Carletta Jackson Lane, co-chair of the Behavioral Health Commission. To whom it may concern, I will unfortunately be out of town at the biannual conference of the NCBW 100 San Francisco chapter in Black Women's chapter in Orlando, Florida, from the 6th of October through the 10th of October. I would like to provide my testimony in support of the Executive Director, Jeffrey Greer, of the San Francisco Behavioral Health Commission. The San Francisco Behavioral Health Commission has followed the appropriate posting procedures, agenda, and supporting previous minutes, and attachments such as resolutions and department reports for SFDPH and MHSA, Mental Health Service Act. The San Francisco DPH IT Department Technical Systems Support Team is the official process for the commission and board meetings with a 72-hour posting window to the public. If you have any other further questions, please contact me directly, and I can send you her email and phone number. She was very reticent of having Mr. Hillier have access to that. And that's all that was said. She was just verifying the fact that at the end of the day, if you're going to verify whether a posting was timely, whether an agenda actually took place, a meeting actually took place, or anything of that nature, that the IT team would be the final date stamp on that. And that's it. That's all.
Okay, thank you. All right, members, question and answer, clarification period. It's the items with you. All right, I'll start the ball rolling. Mr. Greer, can you explain how the Behavioral Health Commission is not required to be compliant with Section 4101 and in et sequitur and the applicable additional provisions of the charter?
Are you meaning of the charter? I cannot explain it because it was a legal document. It was forwarded to me by the city attorney that the Behavioral Health Commission does not fall under the restrictions of a charter. It's not considered a charter organization. I can forward it to you later. I can access it. I don't have it with me.
But Mr. Greer, we're here now. This is the hearing. This is where we need to know what that is. Otherwise, it makes it difficult for the task force to make a determination as to whether it's exempt or not.
Well, under the code, wouldn't the task force know? Doesn't the task force know that code?
I'm sorry?
Code that I read. Are you familiar with the code that was read?
The code, yes, I am.
SC code 4.1.101.5. This is what I was given by my attorney. That is all I have.
Yeah, well, but you made a claim that the Behavioral Health Commission, that 4101.5 is not applicable, but you're basically saying that if it's not applicable, then you're saying that the commission is not applicable under Section 4.101. 4.101.5 applies to 4.101.
No, I'm saying section 4.101.5 dot is stating that the Behavioral Health Commission is not a charter commission. And since it's not a charter commission, it's not subject to holdover limits. That's my understanding. I'm not an attorney. I do not know the specifics. That's what I was given.
Okay, so let's be clear on the exact letter of the law here. Let's start with section 4.101.5. It's titled Holdover Service by Board and Commission Members. A, the application of this section. Unless otherwise provided in this charter or required by law, the requirements of this section shall apply to members of each appointive board, commission, or other unit of government of the executive branch of the city and county, or otherwise created in the charter, period. So there's two conditions. So either it was created, let's say, by the mayor, or by an ordinance of some sort, and that it's part of the executive branch, or it's a charter commission. That's irrefutable, and there's no implication here.
Okay, and as from what I was given when posing the question to the legal entities that we're working with, which is the city attorney, they stated clearly that the Behavioral Health Commission is not a charter commission. Do I know whether or not it was appointed by the mayor, or whether I can't answer that question. I do know that they have stated clearly that the Behavioral Health Commission is not a charter commission. I can forward it to you if you'd like.
Well, but the point is that should have been part of your, defense, your response, for us to be able to see that today. I'm not going to continue this item. So okay. we're going to make decisions based upon the evidence that's brought today. If you can't cite a section of laws required by the ordinance to declare some sort of exemption, then you're leaving us not much choice as to how we make our final decision.
Okay, I was unaware that you needed supporting documentation for this item, but and that and if I was supposed to have that, then I should have had it, but I didn't. I did not know. I thought that all I had to do was let you know what the charter was, let you know what the section was, the code number, and that was it. I didn't know you wanted to have the entire thing written out.
Well, it's just you made a specific claim, and that claim is not specified in the charter section you cited. If you're going to claim that the Behavioral Health Commission is not, section 4.101.5 is not applicable to the Behavioral Health Commission because it's not a charter commission, then you have to tell us where in the charter or somewhere else that it says that the Behavioral Health Commission is not a charter commission. Okay.
I can't tell you. I can't tell you any.
I'm sorry?
May I interject?
Yes.
As the Rules Committee clerk, I can tell you that the Behavioral Health Commission is based on state code. I can give you that in just a moment. It's based on California Welfare Institute Code 56004, and it was instituted by Admin Code 15.12. So basically, it's a state mandated item that was adopted by the city.
All right, please. Can you repeat that, please?
California, it's the California Welfare Institute Code 5604 is the enabling legislation, and the city, through Administrative Code 15.12, created the Behavioral Health Commission, but
Okay.
it was based upon state code. And I am looking for that right now. If you,
I have. So the commission is created on, it's at the beginning of chapter 15, the mental health service. And section 1512, right, Behavioral Health Commission.
yes,
So the Health Commission is established by Mental Health Board pursuant to requirements of California Welfare Institutions Code 5604 sequitur, to be known as Behavioral Health Commission. Commission consists of 17 members. Each member of the Board of Supervisors shall appoint a member of the commission. The Board of Supervisors shall appoint the remaining 6, one of whom should be a member of the Board of Supervisors. Okay, as far as 1512 is concerned, it sounds like it is an appointive commission. Now, because of the way it was established, the question is whether it's a state body or whether it is a requirement of state law that a local agency have one. Okay, and the determination is whether this is a local agency commission or whether it's a state commission. And I'm not hearing that. Any other task force members? Any other questions or comments? I'm going to look through this a little bit.
I mean, even though we are bound by state regulations and follow them to.
Well, so are we.
Never mind, go ahead.
So are we. We're bound by the Brown Act and the California Public Records Act. I mean, lots of state laws bind local agencies. So, and all our, our local departments and agencies are bound by lots of state laws. So, the question is the creation of the commission is as to whether it is exempt from the city charter. That would be somewhat unusual that would be the case. Members, burning time here. Go ahead, Vice Chair Yankee.
Thanks. For trying to decide if this is a part of the executive branch, I'm not sure it is. I'm looking at admin code section 15.11, subsection A, and it talks about the chief executive officer. And it says the director shall serve as chief executive officer of the community mental health service and shall be responsible to the board of supervisors. And there's some other references throughout that code about the board of supervisors. And so I'm wondering if this is actually not an executive branch, so to speak. That then still calls into the question about whether or not it's a charter commission. I'm not sure if 1511 or ever the admin code in general would make it a charter commission.
Can you repeat that section again?
Yes,
one?
on admin code 15.11.
Oh, .11, okay.
Yeah. And I don't see a mention of the mayor in that section. It seems to be responsible to the board of supervisors. So I'm just wondering if that means this isn't actually, almost the part of the legislative body rather than the executive branch.
Which is, we have our own contention with that.
Yeah.
Mr. Chair, may I rebut, maybe help you guys out a little bit? I know a lot about this.
So go ahead, Mr. Hillier. I'll hear you out. Go ahead.
Okay. Thank you, Chairman Wolf. We never claimed that 4.101.5 applied to the commission. And even if it did, it only allows holdover service for 6 months. We have people on the board who've been there for 3 years. They're ready to start over on they're ready to start over on a brand new appointment after the 3-year gap because they've been holding over for that long. And I don't think it does apply. This organization was created on April 10th of 1958 through ordinance number 193-58, section 3 of which creates it. And that is now in section 15.12 of the admin code. It was created by the Board of Supervisors. It's not part of the executive branch, doesn't advise the mayor. There are no appointees of the mayor. It advises the Board of Supervisors and various other people, some of whom are in the executive branch, but that's about the only connection to it. It is governed entirely by its by governing laws 5604. I'm sorry. If I could give you a reference, P 431 in file number 20143. The last paragraph of the page, it cites California Welfare and Institutions Code section 5604C, and it relevantly states that the term of each member of the of the board shall be for 3 years. ... End quote. That's really the only relevant code here. The charter does not apply. This was not created in the charter. The board was not created by the voters. Everything in the charter was created, was passed by the voters at some point in a ballot in San Francisco. And the Behavioral Health Commission has no part in it.
Okay.
Back to you, Matt.
Appreciate that. Thank you. That I think that clarifies things for me quite a bit. Okay, so okay, that's fine. Any other? Okay, so I have I'm not sure who was first. Let's go with Member LaHood first.
Yes, thank you. I was just looking at the Sunshine Ordinance, and I want to point out in section 67.3, if we go down to D7, any advisory board, commission, committee, or council created by a federal, state, or local grant whose members are appointed by city officials, employees, or agents. So I think that covers us here.
Yeah. Okay. I'm sorry. That was D3? Yes. Okay.
67.3C. No, excuse me, D7.
Oh,
67.3 D7. Yeah.
Well, okay. Let's look at that a little closely. I mean, it says any advisory board, commission, committee, or council created by a federal, state, or local grant. Whose members are appointed by city officials, employees, or agents. I'm not quite sure what that word grant means. Let's DCA Castillo, are you still here?
Yes, I'm here.
Okay, I'm wondering if you can maybe explain the intent of that word grant in 67.3D7.
The computerized message. Go ahead.
67.3D7.
I'm sorry, can you start with the beginning? What was your question? I didn't catch any
The question is I'm sorry, the word grant, what is the implication of that word? What does that mean in this respect?
I have no idea. I would have to look into that further.
Okay.
Yeah. And I'm not addressing the substantive issue, but one point that the speaker for the commission raised, I just want to say that any written privilege communication, he can't disclose that without a waiver from the body that holds the privilege. So he doesn't hold that privilege. And so I heard him offer to send it to you or to the commission, but he would have to check with his with the body, which I think is the commission that holds the privilege, but he can't waive that on his own.
Yeah,
duly noted. Duly noted.
Yeah, so I'm not addressing the substantive issue since there's an ethical law. But
hold on. I hear you, but I'll tell you this, that the task force has for almost 20 years now disagreed with that interpretation, because the ordinance specifies that those communications are not to be that way, despite St. Croix versus Grossman, which we feel that there are anomalies in there. So I hear what you're saying, and I know that that is kind of the precedent that has been, kind of unchallenged at this point, but it is it's something that the task force has held for a long time as not correct. But granted as it is, there's not much that we can do about that.
Right.
But
all I can do is give advice.
I hear you. I appreciate the advice.
Yeah.
And I hear you.
No, I just wanted to remind the speaker. So be it.
Yeah, I understand that. It's somewhat inappropriate for you to do that because you work for us, and there is
actually, I would like to address that one point. I can't speak to the substantive issues that he is talking about and the advice that he's been given, but to the extent that we are talking about privileged communication between the city attorney and the client, I'm just reminding the speaker that the privilege is held by the person who received that communication. So that's all I was doing.
Okay, I just, we're sensitive to the ethical firewall. That's all.
So am I.
And so when advice is being made by our legal counsel to a party, even if it's a reminder of what they're supposed to or not supposed to do, it does trigger something for us.
Sure. I was just, well, then we can turn it around. I guess it's to remind the commission that to ask for a privileged communication, that it is a communication that is privileged because it is one between attorney and client. So, and I wasn't addressing the substantive issues that he was addressing and the specific advice that he was given within that communication. So I understand.
Okay. Appreciate it. Thank you.
Sure.
Okay. Member Schmidt.
Yeah. First, I'd like to just be very clear that the statements that are made by the chair in the form of the royal we, as in the task force says, believes this, that doesn't speak for me. I completely disagree with many of the assertions made by the chair about the nature of the attorney-client relationship here and the privilege. And I would disagree if it came to a vote on something about those. I think he's incorrect about several of the things he said about this. And so when the chair says that it's the task force's position, I have no idea where he gets that from. It certainly, it's not ever been something I've ever had a vote upon. And I think that St. Croix is good law. In fact, it's my understanding that a published Court of Appeal case that's never been, it's never been disagreed with, or it's never been overruled by the Supreme Court. That's sort of the definition of good law. So I want to say I want to make it very clear that those positions on the attorney-client's, on the city attorney's role here are not the positions that I would agree with.
Okay, so let me be clear. Let me be clear. I said it has been held by this task force, going back to its inception, that it is held a certain. It has held a certain position. Now, we have not had up until that, we have not had an action to make a determination otherwise. We've had lots of discussion as to whether something is it's appropriate for attorney-client privilege or not. But the task force has held in many, many meetings, going back to its inception, that it disagrees with that. Okay, and the details around, I think it's worthwhile to have a meeting around that, because there's some details in St. Croix that are not necessarily applicable to how the ordinance holds that particular statement. So St. Croix was about Mr. St. Croix. It wasn't about the Ethics Commission. That's one of the distinctions that constantly comes up, and that was argued by Mr. Grossman, and may he rest in peace. So I just want to say that, yes, I agree. I'm not necessarily speaking for you or anyone here. I specifically said that the task force has held in past tense, and I'll make the additional clarification that since its inception, that this to be true until something changes. Okay, so that and I'll leave it at that.
I agree to disagree.
Okay, very good.
Thank you. And I actually had.
Oh, you had something else. Go ahead.
I had my hand up because I wanted to ask a question of the complainant.
Sure. Go ahead.
Okay.
You have the floor.
Mr. Hilliard, this discussion about the nature of the commission and the status of holdovers, could you explain if you think that affects the validity of your 103 claims of violations, and how would it affect? And I'd say 103 plus the 7 in the other case. How is it relevant?
Thank you, Member Schmidt. It's relevant. I tried to describe that in my opening argument. If you exclude people who are serving on holdovers, you have a very small number of commissioners. At the July 15th, 2020 meeting, just as an example, there were only 3 commissioners there who had current appointments. And there are only 4 overall. So if this commission holds that Charter Section 4.104B applies, I'm sorry, if this task force holds that Charter Section 4.104B applies to the commission, and the word member therein means position, office, vacancy, or seat, then there are 17 seats on the commission. So there are 17 members, and a majority of 17 members is 9 members. And if you don't have 9 members at a...
But you're saying that there's a violation no matter what, regardless of how many people were there, correct? That they violated various provisions. I'm just not seeing how it has any impact on the validity of your claims. I don't see that. In other words, I don't see that I need to even look into those issues to find violations here. But can you tell me what it is that you think how it's relevant to these specific types of violations that you're alleging?
I think he was having some problems with his microphone.
Member Highland here. We're at 50 minutes and counting already on this issue. It looks like the quorum is one part of it. The other meeting violations are a second part, and then maybe documents might be a third part. So maybe we can move on to maybe the other thirds and try and get some discussion on that. I'm not sure we're at a point to decide on the quorum issue right here. Just thought I'd throw that in there.
Withdraw my question. Thank you, member.
Member Highland, did you have something else that you wanted to address?
No, that's it for now.
Okay. Mr. Hillier, are you still there? Mr. Hillier?
Can you hear me? I just got back on the line. I got hung up. I don't know how much of my answer you got.
We didn't get any of it.
Oh, I'm so sorry. Can I begin again?
Yes, go ahead.
Okay, thank you.
For purposes of time, I'm going to withdraw the question. My question was withdrawn.
Okay.
Yeah, I don't need
an
answer.
Okay, I'm sorry, Mr. Hillier.
That's all right.
Okay, so I'm not clear as to whether the what they are calling the mental health service is a local agency or not. Without seeing whatever advice the city attorney put out or provided to the commission, the commission is not using that advice to me with enough substance to be able to determine. It's not so much quorum, but is with regards to membership in order to be able to count quorum and whether meetings were happening or not. With regards to the 72-hour postings, the 72-hour postings, it's not really. I'm not quite convinced that it's based upon the timestamp of Department of Technology, and because the question is who exactly is making the postings? Is it Department of Technology? So let me ask Mr. Greer, who's making the postings when the agenda?
Who is physically posting it?
Yeah.
Physically posting the DPH IT department.
Okay, and are they posted anywhere else?
Yes, they're posted at the public library.
And are they posted at the clerk's office?
At the clerk's office? No.
They're not posted at the clerk's office. Okay.
No, they're required to be filed with the on the website that is posted on the Department of Public Health website, and for public access, the public library. So anybody that does not have access to the DPH website or does not have a computer or anything like that, they can easily access the agenda and the minutes at the public library.
Okay, thank you. Any other questions or clarifications? All right, should we move to rebuttals?
Actually, sorry, I couldn't figure out how to raise my hand for the moment. This is Member Stein.
Okay.
I did
You
want to
can
ask.
just speak. You can just speak up. It's fine.
Yeah,
You know,
sorry. I did in the end. So I just wanted to ask another point of clarification from the representative for the respondent, which is that I understand why you're saying that you feel you met the requirements for trying to post, more than 72 hours in advance. But I also recalled in this packet that that the Behavioral Health Commission does accept that they didn't really describe agenda items very well.
No, that's not. I don't think that's true. Not that part. Description of items in the agenda have been. Well, I'll let you go ahead. I'm sorry. I didn't mean to interrupt. I'm sorry.
Yeah, I don't think I wrote the page numbers that I saw that at, but I know that was in the packet, that there was a acknowledgement that some of the agenda items were vague, and that since these postings, people have undergone training and they understand that the agenda items need to be more descriptive. I would have to go through all my highlighting to find exactly what page that was on. But so you're saying you didn't say that?
Could I clarify?
Yes.
Okay. During that time period, and I think it was probably one of the first hearings, and it was probably my first, I was trying to be genuine and forthright into what I realistically thought happened. I had no definitive idea. I was not present. As I said, I'm trying to piece together a lot of history that I don't really have. Since we had that conversation, I've had an opportunity to go through some of the historic agendas that have been posted. And quite frankly, items that are clearly posted in the agenda seem to follow the description of seem to follow what was being discussed. There is no one else, absolutely no one else, that has raised any kind of complaint